Welcome to Compliance Therapy with Igor Volovich, presented by Qmulos. Qmulos, converged continuous compliance. Get it together.
Hello and welcome to another episode of Compliance Therapy Podcast with Igor Volovich, sponsored by Qmulos. Joining us again today is a legal mind of great caliber, Miss Heidi Saas. Heidi, hello.
Hello, my name is Heidi Saas, a data privacy and technology attorney. These are my personal opinions, not legal advice. And doctor, I did not think I would have to be back so soon for more therapy, yet here we are.
Well, therapy is sorely needed.
So soon. Tell me about it. We saw it coming.
It's, absolutely right? We didn't think we'd be talking so soon, but I'm really happy that you have the time. And unfortunately, we are being driven by circumstances beyond our control, right? The news cycle is demanding that we participate, so we will. So the story is the SEC, SolarWinds. SEC has charged SolarWinds and the company CISO, Tim Brown, with basically shareholder fraud, right? Investor fraud. And what they're incriminating in a 68-page complaint is that Tim Brown, the CISO, and the company knew or should have known and has misrepresented and continuously has done that, misrepresented their security posture to external parties, including the SEC and just the public in general, right? So basically what they're saying is the shareholders were maligned. They were actually not maligned. They were defrauded, right? They were not given the opportunity to understand what the implications were of the diminished security posture of SolarWinds. And of course, SolarWinds suffered a breach. As we know, it's called Sunburst. And the stock took a dive, 25%. And that kind of kicked off the action with the SEC. Then, of course, there was a shareholder derivative lawsuit, a Kitama action. So we've got a lot of things going on here, a lot of things to talk about. But the big thing that's really burning up the news cycle is Tim Brown getting charged individually and all the CISOs losing their mind about it and asking for directors and officers coverage. So that's where we start.
Yeah. So on that issue, shame on them if they didn't already have the D&O coverage. CISO is a dangerous job. I mean, really. And there are obligations that come with this. If you didn't foresee that, then maybe you shouldn't be in a role like this, because this is where the trends are going. I want to separate this from the Uber case a little bit because everybody got upset about that CISO too. Remember, that guy used to be a prosecutor. So, I mean, there was bad blood in the whole situation. There were other things going on. Not only that, there was a breach and he lied about it, said it was part of the bug bounty program to try to cover it up. So, I mean, that was a separate incident, where the CISOs were like, oh, as long as you don't do crime, you're going to be okay. This goes a little bit further. These are serious allegations against the CISO saying that your department was so sloppy and you knew how sloppy it was. And then you went and made other representations or signed off on representations that were made to the general public. And so, the SEC rules are from 1933 and 1934. Yeah, they've been around a long time. So, I mean, this isn't like a new technological kind of thing. This is an old-fashioned fraud case is what the SEC is alleging. So the fact that CISOs didn't see this coming is short-sighted on their part. Like, why are they not talking to their counsel? Why is their general counsel not saying to them, where do we have gaps? Where can we button things up to make sure that things are tight? Because what we represent to the public and what is going on in the background, there is no mystery to protect us anymore. No one will protect our confidential, proprietary, arguments that we have anymore because there are other rights and obligations that we have that outweigh our corporate obligation to try to keep those things confidential. So you can forget about that. Like the tide's rolling out, we're about to see who's swimming naked. So you need to get ready and you need to be friends with your lawyer because everybody loves hating a lawyer till you need one. So why don't you talk to him before you need one? And, maybe that mountain won't be so much higher to climb if you have some help.
Yeah, well, that's the thing. And I'd love to pick your brain too on this idea of, A, plausible deniability, B, the idea of prior knowledge. Right. And I think also the idea of how do you determine intent, which I think is always the thing of all the mens rea, right? As they say in the legal profession, the guilty mind, okay, how do you prove that? Well, because we're not living in 1934 and we actually have all kinds of communications that you can discover through a subpoena, which is exactly what I suspect the SEC did, but they have access to their Slack messages, to the email messages, to the instant messages. They have their senior engineer in the security department literally saying, I just got off the phone with a client and we just lied to the client because they claimed that they actually had what's called SDLC, which is secure development lifecycle. Basically, they were using secure coding practices to design secure products. That was a misstatement. Let's being charitable here, right? It was a lie. And their senior engineer admitted it on a Slack message. And so, yeah, we're not living in 1934. You can actually determine the guilty mind because we have access to what they were saying at the time, which demonstrates intent, that demonstrates their real state of mind. So this idea that we can hide behind NDAs, we can hide behind this confidentiality, it's gone. Everything's out in the open. Everybody lives online, and every thought is captured for posterity. And when it comes to these kinds of actions, this is going to come to light. Now, I don't want to go too far down the field here, but there's a narrative that's being developed right now that I'm seeing out in the press, that I'm seeing out online, on LinkedIn, where folks are kind of trying to be helpful. And they're saying, well, the answer to this discoverability is to not put anything on Slack, on email, and kind of, pick up the phone, call somebody. And that way, the SEC can't come bite you, right? I think that's more malfeasance on top of malfeasance. Now we've got a rushing nesting doll of malfeasance kind of brewing up. And I think that's really unhelpful. What are your thoughts on that?
It sounds like good advice if you're an organized crime, but right? Like,
don't say nothing to nobody.
It's Fight Club. First rule of Fight Club: don't talk about Fight Club, right? Like, I don't know that is a good employee training measure to follow. And I'll put it this way: I've seen trends over workers and the ebb and flow of consumer rights and truth and justice, those sorts of things. Generation X, my generation, you go to them and you say, hey, we got this problem. I found this thing. And they say, wow, that's interesting. Don't ever show anybody again. And then you're like, ooh, that's shady. And I'm a little afraid of that. And then you go and you deal with that. And you like document it, like who told you not to say anything. So you don't go under the bus and like you walk away. Right. You could, we're the last generation that would do that. Personally, I don't really get into doing all that, and I can't because I'm a lawyer, but I see it all over the place. It's human nature. It doesn't really change. The generations after us, like they're not having that. They know BS when they see it. And if they, they have that truth or justice, drive because they've seen how other things have been done and they want to change things for a better future. So they want to speak out. And so if you don't listen to them when they say, I found something and this is not okay, and you tell them you should hide that and never talk about it, you are going to get gaslit so fast and in so many different ways. And if you don't have an outlet for them to bring that internally, they're going to find somebody else to talk to about this. And I promise you're not going to like that. So, I mean, I applaud them for their bravery in doing this. Change is made in such ways. It's also dangerous. But I see this as a trend, and it's part of the makeup of the humans that are doing this work now. That's why you're seeing more Keaton cases, and you're seeing more people come forward as whistleblowers under other statutes. So this is the world we live in now. So if you have something to hide, it's definitely time to clean that up, like right now, because it's not enough to say I sat through this presentation and I wasn't really paying attention because I was really playing Candy Crush. And they told me everything's broken. Like, you can't say that I had the intent to bring down the whole system by being so reckless because I sat through that presentation. Like, we'll see. But you're right. We do have evidence of, what you were thinking at the time and what was going on. But in this role, there's a lot. Everything's on fire everywhere all the time in this kind of a role. So, I mean, you've got to have teams of people to handle these things. And honestly, you've got to document what you're doing about these things. Like, the don't write it down is not really good advice. Quite the contrary. You should document, we had this issue, we talked about it, here is the result of the issue, or you had delegated that effectively to someone else. So that and the issue doesn't just stop with you. Because if you do, then you have to start hiding issues, and eventually you're going to get discovered, and it could rise to the level of fraud.
And that's exactly what we're talking about. I think, look, we can talk about some of the legal concepts like defensible deletion, right? And then preservation, right? So I remember I went to a conference years and years ago, and it was actually a legal conference, and I was there as a CISO, and it was kind of an oddball, attendee, but we got, I got to be at a presentation with a federal judge who actually wrote, he set the precedent on what defensible deletion practices were at the time. This is about a decade ago, and I forget his name now, but fairly famous circuit federal judge, and he was there, he was presenting, they were talking about it. And one of the folks who invited me there was actually an attorney, a very prominent attorney, and her entire practice was really wrapped around defensible deletion. Where do you set that limit? And, you can't just write a corporate policy and says, we delete everything after 6 months. A, you can't do business that way. B, it just looks shady as heck, right? Yeah. And so, you don't want to get into the conversation around Anderson and what happens with Enron. You don't want to be in that spot, right? So you have to have some record preservation. Now, I was on the other side of this. I was under 2 consent decrees when I was at a certain company many years ago, so I might probably imagine who that was. We had a couple of consent decrees from the DOJ. They had to do something with antitrust. We had to preserve records. So you're between these 2 places, like the rock and the hard place. On the one hand, you want to delete as much as you can to limit, let's call it exposure from discoverability perspective, and also from a cost perspective, right? Because discovery is expensive. On the other hand, and you got to manage all this data as long as you keep it. So keep as little as you can. But again, it has to be defensible. That's why we call it defensible deletion. So this notion oh, crap, they're looking at what we're doing. We're doing something bad. Let's go and hide it by deleting it. That just, it's got malfeasance written all over it. And it's negligence where it transitions to willful negligence. And then it's actually demonstrating intent. That's mens rea. That's where it is. There's your guilty mind showing that now we actually got to look deeper. What is it that you're hiding, right? I think you're inviting more scrutiny as opposed to avoiding it, right? And Heidi, you're muted.
Sorry about that. The dogs are barking again.
I think the noise suppression is doing a good job, actually.
Yeah, I want to talk about Google for a minute here. So in the antitrust trial, part 1 of the antitrust trial, and there are 2, part 1 was happening in DC, and we don't really get much information out of it, but we do know previously they have been charged with spoliation. Mm-hmm. That is intentional destruction of evidence that was subject to an ongoing investigation because they were given orders, don't destroy your stuff. And then they are bringing in evidence saying, no, they told them to go to ephemeral messaging so that it would disappear if you were talking about these sorts of things. They trained people on this. It was employee training in a bad way. And so now, that really came to light and it doesn't look good. How do you defend that when you're talking to someone and say, ooh, let's take it over here? Likewise, the SEC went after a bunch of different banks and whatnot for their brokers using Signal and other ephemeral apps to do the hot and juicy information trading that they were doing. And there were rules to prevent them from doing that, but they thought it didn't apply because it was such a new technology. People don't understand that I don't care how new or magical you think your widget is. We have had laws to protect the behavior that you're exhibiting with these tools for a very long time. The problem is people don't know consumer rights, and that's the difference. You understand consumer rights, you can see where all of the existing laws are that prevent these sorts of things from happening. So, like the rise of GPT, it was introduced a year ago, people lost their minds. And now they're wanting to implement it into everything. And it's at the point where we've realized the problems with it. Now the companies are saying, but if you subscribe, I will give you indemnity for any copyright claims that you may come across and those sorts of things to try to sweeten the pot and fix some of the deficiencies that they have. I honestly think the ebb and flow of GPT is going to be a faster decline than crypto. Because there are the content creators. There's so many more litigants to come after you when it comes to these large models than you have with the crypto exchanges, right?
Yeah, of course. Well, and I think you said an interesting word there, right? Indemnification. So we're seeing this new movement, I guess a renewed movement emerging in the wake of this SEC SolarWinds issue, where a lot of folks are coming out, folks who are practitioners in the cybersecurity profession and the leadership roles, CISOs themselves or aspiring CISOs, who are saying, look, I want to be indemnified. I want to be protected. I want to be included in the directors and officers, or DNO as they call it, policy. I want protection. I want indemnification. I want to make sure that if I make a bad decision, that I'm going to be protected from some bad outcomes like a breach. And I think they're missing the point. And the reason I wanted to get you on the podcast so soon after the news broke and kind of capture it, get it out there, because I see a lot of kind of misinformation, right? Folks are kind of misinformed on this. They're playing kind of, lawyer on TV. And, as a guy who plays doctor on TV, I should probably, take that with a grain of salt. But that said, the idea that Mr. Brown the CISO of SolarWinds, he's being penalized or scapegoated for the breach, or the company's being penalized for the breach. They're not. The breach was, as I like to call, the breach is the ultimate audit. In their case, it was the ultimate audit. It exposed the lack of maturity in their processes, the lack of maturity in their controls. It exposed it. It broke it out for SEC to see. And when the SEC looked at the breach and they said, look, you've been filing regulatory statements, S1, S8, 10K, 10Q, and consistently using literally the same boilerplate language in every one of those statements saying, we have no known material defects. And then it was very flowery, very nebulous, kind of very, generic language around, well, we do face certain risks, and if a breach were to happen, there could be some damage. While they knew specifically that they were having very poor practices, that their product itself that was sitting across so many different environments, so many different networks, including government networks, that it was faulty, that it had very serious flaws, and it was open to remote access by nefarious parties, that their authentication mechanisms were very poor, and that is exactly what was exploited. So this isn't like, not to get too technical, and we got really technical in a second here, right? But what people, and I think you made a great point, the laws that we're talking about are from 1933 and 1934. Just like the First Amendment still covers, right, the electronic press, even though they did not exist, and people try to make that argument, but wait, right? No. It's about fraud. It's about transparency. It's about shareholder rights. It's about the market integrity. It's about the fact that people need to know what is the state of these companies that they're investing into. And they were denied the right to know. This is what it's about. It's about transparency, integrity, and confidence in what you know about this company so you can make a good investment decision. And we all get it, right? Hedge funds don't necessarily look at somebody's, or pension fund is not looking at somebody's security report, but they assume that it's included, and that's a very bad assumption to make these days, right? But they assume that what they're stating in their quarterly filings, their annual filings, or their filings to go IPO, like in the case of SolarWinds, that they're saying the truth, right? That they actually can rely on these statements, and these statements were false. This is what this case is about, not the breach.
Mm-hmm. So who prepared those statements?
There's a good question. And, and I think this is where we need to go to the crux of it. The divorced nature of compliance and security. I'm going to get on my soapbox again here, right? And you've heard me say this before, and I think a lot of people have heard me say this. Like this idea that security and compliance operate in these two different spheres, that these are two different animals, right? And that's why I call this compliance therapy, because we have to be therapeutic about it. We have to get the family back together, compliance and security, under one roof of risk, really, right? And trust. I mean, ultimately, it's about trust. And how do you establish trust? How do you assert trust? Well, you assert it, and then you have to get validated for it. And that's what audits are meant to do, right? But unfortunately, audits are very short in scope, they're time-boxed exercises, right? And you can only look at so much. And then it kind of depends on the subjective opinion of an auditor, or the kind of relationship you have with an auditor. You can do opinion shopping with audit firms. Happens all the time. And then, yes, by law, you're supposed to switch auditors, et cetera, et cetera. You can keep playing that audit roulette till you get the right number come up on the roulette wheel. And this happens all the time. And we've seen the limitation of audits. They can only see so much. They can only look at so many things. So you're extrapolating, you're making proxy statements about a little bit of what you saw, and you extrapolate.
That goes back to your prior notice argument. If everybody was auditing everything all the time and they documented that, unless they went and took action on those things or documented why they didn't take action on those things, they may be creating additional liability that didn't exist before, because it's not plausible deniability unless there's harm as a result. So when we're talking about SolarWinds and everybody's worried about, the SEC filing, and the shareholders were misled, and if it was intentional, then it was fraud, because that's as far as you can get down.
That's what they're alleging. Yep.
Exactly. Right. Well, I mean, that's pretty far. Those are serious allegations. And people are like, oh, the poor shareholders. Yes, but how about all of the businesses that were a part of the breach and were impacted by that breach? How about all of the consumers whose data were being held by those businesses? That's where I'm thinking, the scale of the harm is, the scale of the harm is so much bigger on the consumer side here than the people who are being held to account for this right now. They're not the last, and they're not the only. So, I mean, there are other cases ongoing at the agencies everywhere right now, all day. I mean, really. So this is not it. This is something that should get your attention. It is good legal advice, I would say, for the CISOs to say, I want more insurance. I mean, that's kind of the Band-Aid that lawyers go to when they're dealing with businesses. Oh, you have a risk? Well, let's do this and document it and then get some more insurance for that. And we've mitigated the risk. I think, why don't you fix the thing? It's a better idea, but it's not always an option. So it's not a bad thing for them to ask for the D&O coverage, but it is not going to cover whatever you already had ongoing before. Mm-hmm. So yeah, I mean, so let's think about where you are now. And if you have that kind of level of trust with your employer that you're like, I need a parachute and you need to get that set up for me like right now, you've got other issues that are pretty serious as well that require additional advice from other people. So yeah, I don't blame them for asking for that. And I understand why they're being told this is probably something to remedy the situation. But the bigger issue is your whole enterprise had communication problems because your people identified the issues and then nothing was done about it. So in theory, you had the right people to find the problem and fix the problem. So why didn't you fix it? And we don't know. That's why
we don't know. Yeah, and I think
why we have cases to go to trial and discoveries.
Thank you.
More evidence and testimony. And these sorts of things can come out, and they set an example for other businesses so they know, oh, here's the really wrong way to do that. Right. And it creates a deterrent effect. So other businesses will really start to pay more attention to the compliance department because it impacts your marketing. If you don't handle compliance, you won't have anybody left to market to.
Well, and I think you asked a great question, right? How are these statements prepared? Who prepared them, right? Like who done it of it? I mean, I think I said it online too, that we'll find out as part of this case, right? And that's the point of this case, is to find out who actually is responsible. The funny thing is, so depending on who knows in the audience what a Wells notice is, but basically it's the SEC's version of the target letter, right? So a Wells notice is something you receive from the SEC that says you're subject to an investigation. You have time to prepare your defense. And so the Wells notices were actually sent out to both the CFO and the CISO. And the CISO is the only name whose name wound up individually on the complaint. So that tells you something, right? And when we know who signs these statements, right? These are regulatory statements that are signed by the CEO and the CFO typically, right? And so the CFO's name is on the statements. He is ostensibly responsible for making these material misrepresentations, but he was not charged. Now, this is not to say that the SEC is not going to come out with an amended complaint or an extra complaint, or there's going to be a second case. Or maybe he cooperated, and maybe that's why his name is not on the complaint. We don't know, right? We'll hopefully find out. But I think it's rather telling that the CFO was not charged and the CISO was. And the question, again, back to your question, how were these statements allowed to be prepared that obviously contained knowingly false information, misstatements of fact, material misstatements? And then also there was the other case, the other issue of the 8K. So the 8K was the material event incident, right? And so the material event incident, also, they downplayed the scale of the attack, they downplayed the severity, exactly what you talked about, the cascading effect, the second, third order effects, all the other companies that were impacted by this, and all the consumers from those companies whose data was impacted, the privacy impact, they omitted all of it.
Do you suffer from seasonal compliance fatigue and chronic compliance headaches? You're not alone. Countless IT, compliance, and cybersecurity professionals just like you continue to suffer from legacy compliance, audit, and assessment workflows, excessive compliance paperwork, and manual evidence collection. Sadly, most have just accepted the idea that compliance management must always be difficult and unpleasant, but it doesn't have to be. Qmulos, an industry leader in converged continuous compliance, has developed revolutionary treatment options to relieve your compliance-related stress, delivering a fully automated end-to-end compliance experience. Don't delay. Call today for a free consultation with one of our compliance therapists and start your journey to converged continuous compliance by Qmulos. Call toll-free 1-844-476-8567 or visit Qmulos.com to start your healing journey. That's Qmulos.com. Qmulos, the compliance automation you need, the compliance experience you'll love.
They knew how bad it was. They should have known. They were in a position to know. And the internal communications confirmed that they did know. So this idea of like, oh, shucks, we had no idea. Yes, you did. You were saying one story internally. You were telling another story externally. And what bothers me, having been a CISO, having worked for public companies pretty much for the majority of my life, the ethical obligation. Like, how does a person who is ostensibly a corporate officer, and we can have a whole other hour just talking about what a CISO is and is not. I'm fond of saying the C is silent in CISO, and so it's kind of they're not really corporate officers because they don't sign off on anything. They go and talk a lot and they scare people like what happened here, and nobody listens. Or if they listen, they kind of ignore. And so let's talk about, and we can talk about what happened with another person who worked there, but staying on this topic, they knew, they were told, the CISO knew, the CISO told, and then he still should have known, but whether he personally allowed this to happen, I guess it's up for debate. I guess we'll find out as part of the case as it proceeds. I'm definitely very curious about that. Like, where was the divorce? Where was the gap, the delta between what they knew, what they were saying internally, and what they were saying externally? And by the way, the SEC is not just looking at the regulatory statements. In the complaint, like literally page 2, they're saying there was a corporate security statement on their website that said, here's all the stuff that we do to be secure and keep our products secure. Mm-hmm. And SDLC, the security development lifecycle, which was a thing that Microsoft invented 25 years ago when I was there, 20 years ago. And they focused on that. They said those 4 letters is really what's bearing them here. That's what's sinking the ship, is they claimed they were doing it, and then internally were saying, oh God, we wish we had 2 years to actually get there. And then there's that Slack message, the infamous Slack message with the...
That goes back to what I was saying about you have to be honest about what you are telling in your representations to the public through the websites and the marketing statements. The 8Ks that are filed, there are bots waiting for those 8Ks to show up that immediately impact trade prices. So, I mean, it's, the stock market is impacted when those 8Ks are filed. And businesses know that. I mean, I think you said it yourself, 25% was lost in the first day when they started to bring out their debt.
And that was even on the incomplete news.
Right. Yeah. And yeah, exactly. And so that tells them there's a lot more at stake here, but you can't really hide these things. They are going to come out again. So like I said earlier, you've got to be honest about the representations that you're making to the public and what's actually happening in the background in your tech stack. Like simple things, like if your cookie says don't collect data and then you show in the background that it's still collecting data. I mean, exactly. That's enough.
The problem.
That's enough for somebody to have cause of action against you. And for business owners, there's a lot of money to be spent, whether you're in trouble or not, just to figure out if you're in trouble. So, I mean, you want to avoid these simple kinds of mistakes. And how do you do that? Validation. You've got to know where the issues are, and you've got to know technically how to go in behind to find out, is what I'm saying the truth behind what's really happening here? So it is where the culpability of the law attaches to the code. And so that's the important part that people need to know. This is where the harm happens. All of these apps and codes and things that are built, the widgets, they have instructions within them on how they're supposed to operate. So if you don't address those issues, because the developers didn't know they were making ethical choices, if you don't address those issues, then who else will? And if you don't even look into those issues and you don't know how they work, the explainable AI part of it, I'll tell you right now, knowing nothing about it and acting surprised when something bad happens is not a good look. Your insurance companies aren't going to help you out with that. It's not going to be good for you anywhere. Yeah.
Well, good luck getting insurance when this is what's happening. And I think you said something that's really, really important, the validation, right? The typical, the traditional model of validation, right, of trust has been mostly built around compliance and this compliance culture that's emerged, right? That's completely divorced from reality. I think if this case is about anything for me and this news story is about anything for me, it's about the failure of this legacy compliance culture that basically determines that compliance is this other thing. We just do compliance over here, full stop, pause, then we do security over there. Then we do risk somewhere in the middle, maybe, but kind of divorced from all of that. And so there's this very siloed, very segregated kind of thinking around it, right? And these things all tie together. because we're still talking about the same thing, except you've accepted this notion that compliance happens on a cadence. It happens periodically. It's this thing that oh crap, it's time for the audit. Let's remember about compliance. Let's go collect all these things. Let's go collect this evidence. Let's go make these data calls and then shove them into the auditor's hands, have them do this for a month, charge us a bunch of money, and then print this report that says, well, to the best of our ability, based on the data that we've had, disclaimer, 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 within the scope, disclaimer, 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 right? We have seen this and we kind of have a general judgment call on the general health of your practices. Like, okay, thanks. Wipe hands on pans, repeat next year, right? That's the compliance culture. And I say
disclaimers right there, shifting liability. No, if this happens, it's your fault. But no, if this happens, it's your fault. But no, it's this happened. Well, people don't remember that, there are cybersecurity rules and there are privacy rules and there are jurisdictional rules. Like, it depends on where you are and what you're doing and what kind of data you got and who you are. And that will determine how you need to treat that data. So my favorite thing is when people have those pre-made privacy impact assessments, you can click it and it'll be like, gather all the information, be like, here you go. No, how is this going to capture that one file that is your whole DSAR process that's in Bill's email inbox? Like, no, that's not going to work. Like, you need the data map, you need to go through all the different tools that you got. Most companies have way too many tools, so you need to clean that out too. Especially when other tools that you're already paying for have additional capabilities. So where do you have overlap, and clean that up? You don't know unless you get in there to find out what's going on. So the explainable AI, that's important. For the CISO, also important, because if they had come to him and said, tell us where your deficiency are in your department, what you're doing about it, and he said, listen, I have these challenges and I'm working on these issues, and he started to work with the investigators, that maybe have been a different story, right? But instead, we went a different direction here, and the allegations
conceal. Yeah.
It's gonna take some pretty fancy explaining to do. But like you said, with the indemnity and the liability shifting, it's almost like everybody's dancing. But the rules, liability runs up chain. So I mean, I don't understand sometimes why lawyers put those in there. Like, it's kind of like the spaghetti argument: throw it against the wall and see if that'll work. Like, I don't know that you should include those sorts of clauses in contracts where it's contrary to the nature and intent of the law that you're trying to comply with.
Well, and here's the thing: like, we keep saying compliance, right? And I think a lot of folks are confused about what that actually means. Like, compliance has become this paper exercise, right? And we talk about validation, like, oh, we'll periodically validate that. Well, all you're doing is looking backwards, right? Like, it's a historical reporting function. That's what it has become. Unfortunately, compliance culture has emerged that basically accepts this notion of looking in the past, right? We're looking at history and trying to sort of infer what's going to happen in the future, But hey, as they say on Wall Street, past performance is no guarantee of future results. So I don't care what the control was doing 3 months ago. I want to know what it's doing now. And I think when it came to the story of SolarWinds, like, they had identified a lot of problems, and the CISO, God love him, right? He knew what was going on. Now, let's also remember, he was only hired 16 months before the IPO went through. And like, did he even have the ability to affect what went into the S1 and the S8? Who knows, right? But at some point, there's records, right? And that's what the SEC is referring to in the complaint, is that he had reported this time and again internally. But somehow, while that was happening on this hand, the other hand was filing these statements to the public and to the regulators. And they were known, certainly were known material statements. And that's exactly what they're charging. This is about that. It's about the lie. It's not about the technicality. It's not the fact that the SDLC wasn't fully implemented. No, their SDLC could have not been implemented at all. It didn't matter. They could have not had it, but they lied about it. That is the problem. And people need to really understand this. And I'm going to keep saying it. I'm hopefully you'll help me say it too. We need people to understand this. The reason that he may have had a tough time communicating this in a way that could have prevented this, the only way that could have prevented it is saying, look, here's where we actually are. Here's where our controls actually are. Not, at some macro level, but specifically, right? And doing it on a continuous basis. When we talk about validation, I'm a big proponent of continuous compliance, right? And the idea of continuous compliance is that it's happening all the time, right? And you're doing it with data, not opinion. Again, he was communicating opinions. He was communicating subjective opinions about the state of their program, his program. And it was kind of this exchange of thoughts and ideas. He didn't have evidence. the evidence is now the evidence has become their Slack messages talking about how poor their program was. That's become evidence. Had they actually had evidence of what they were doing wrong, maybe he could have had an easier time communicating this to the board. Maybe he could have gone to a presentation with the board where instead of 10 minutes, he would have had 2 hours going through and saying, this is where we need to prioritize because this is the risk. But it didn't happen because we're basing on audits.
This is important, for CISOs to understand, how much skin they have in the game now, but also this is important for the rest of the board because I'm still hearing from CISOs saying, I need a seat at the table because the board doesn't want to listen to me or they don't understand what I'm saying. So part of a CISO's job is to be able to take the complex things that you're dealing with and translate it into something that they can understand, and they understand the urgency behind the requests that you have. But you have to get their buy-in. So you're pitching. If you're a CISO, you're pitching the board to get, attention, funding, whatever you need to get things done. And if you're not in the room with the board meeting or on the Zoom or whatever, then I think you're missing out. But also you're starting to dig your own hole if you don't start to do something else about it. Because the longer you say disassociated with the board, they're the only ones that can save you here. Because that liability is with them as well. I'm pretty sure in this whole SolarWinds issue, 0 lawyers are going to be held to account for anything they've done whatsoever in any of this. I predict 0 lawyers.
Unless they were actually physically involved in the malfeasance, right? If somebody advised somebody to hide the truth, right? And say, oh, no, we know about it. I mean, I don't think any trained lawyer who's actually practicing, right, in a corporate setting would ever put themselves in a line of fire where they would say, oh, no, let's hide this, right? It's non-professionals. That's what's.
I think you give lawyers too much credit. I know some dumbass lawyers. I've had some dumbass lawyers, honestly.
Maybe it's wishful thinking.
Some dumbass lawyers. Look at the ones who were like perpetuating the big lie and whatnot. They, like Rudy Giuliani and the other ones losing their license and stuff. Before all of this craziness in politics, people thought that they were regular lawyers, just like all the other lawyers that you know. Right. So, I think you're putting a little too much faith in lawyers here. I'm saying that, with the shifting and who relied on what opinion and who was responsible for what, submission and who has the obligation to be honest, the fiduciary duty to be honest here. I'm pretty sure you're going to find 0 lawyers in the back of the paddy wagon. So, I predict that's what you can count on right there. But that is another reason for CISOs to say, I have to be at the table with the rest of the C-suite to make these decisions. And you have to listen to me or I'm going to have to go somewhere else because there's too much risk involved for me to do this job and to do it wrong because you're not the one that's going to be in the back of the paddy wagon, right?
Right. Well, and look, I'm wondering how many lawyers and how much they were involved in this because, look, frankly, my personal experience having been a CISO, having advised CISOs of massive multi-billion-dollar environments, my first instinct is always go talk to a general counsel's office or whoever is the final authority on these things, right? Where I can ask a legal question, where I can ask an ethical question, where I can talk about compliance, where I can talk about risk, where I can communicate that in the context of the overall health of the corporation in terms of our brand reputation, et cetera, right? And a lot of CISOs talk about this stuff, but kind of these very nebulous, fuzzy terms. I go to the general counsel's office talking like we are talking, right? Let's talk about our 8K that we might need to file in 3 months. Let's talk about this thing that happened 3 months ago that, oops, we never told anybody about it. And by the way, you just filed the annual statement and I didn't see anything about it there, right? And they're like, who the hell are you? Who asked you? Like, I know you didn't ask me. But here I am now, and now I'm telling you that I understand the context, and I understand the ethical obligation. And by the way, and I'm going to say this, and I hope nobody gets all weirded out by this, whoever's watching it, right? But there is a reason Civil Cyber Fraud Initiative was stood up by the DOJ. And the reason for that is because they're incentivizing whistleblowers to come out because they realize there's this little veil of obfuscation around this. And cyber is complex, and it's really hard unless there is a breach. Of course, everybody gets breached at some point, but you can't just wait for a breach. We're trying to keep breaches from happening, right? This is not just a law enforcement function. You'll come draw the chalk outline around that body. The SEC is actually trying to manage risk here to a certain degree because the market hasn't adequately priced it in. So the regulators are stepping in. So in that sense, within that context, they want to prevent these kinds of incidents from happening. And if they can encourage better behavior, but they need transparency. They need insight into these environments. And guess what? The whistleblowers are the secret weapon. That is the safety valve. And I think, and so expect the whistleblower, And if you're doing malfeasance, if you're acting maliciously, if you're acting negligently, frankly, I am very surprised that we didn't see Tim Brown act in a similar way to the guy over at Penn State, right? Penn State, they had a minor incident, right? It exposed certain, security shortcomings. And a whistleblower comes out and says, look, we've been lying to the federal government on these contracts. They executed the contracts. It was a research grant through a DOD, right? They did the work. And then this incident exposed that they were actually lying about the thing. It wasn't as massive, not even close, but it's a very similar dynamic. And so my question is, if you've exhausted your internal channels of reporting and you've said, look, we know that we're doing poorly in these areas. These are critical areas. It involves a crown jewel product. It involves a lot of consumers. There's a cascading effect that we might be talking about millions and millions of people being affected, billions of dollars lost in our own stock price, across the board, and across our consumer ecosystem, right? How do you take that statement, put a pin in it, and then go about your merry life and let these 10Ks and 10Qs and 8Ks and then S1 and S8 get filed? Like, do you just kind of put your brain on pause and go, well, that's not my job. This is the legal department. This is our investor relations department. This is our compliance department. I don't know how you do that. And I think a part of the answer is there was a chief security strategist who worked for SolarWinds, who also reported this delta between what they were doing and what they were saying. And he resigned in protest because he could not get them to accept the recommendations. And they told him, thanks for telling us, but we're not going to do any of this. We don't have the money, we don't have the time, we don't whatever. We don't have the resources. We're not doing it. And he left because he was not going to be, let's call it, a party to these shenanigans. Mm-hmm. And so I've had conversations with people where they go, I can't speak out of term. I'm not an attorney. I'm not a compliance professional, but you have a duty to report. And I think a lot of CISOs, especially CISOs, need to understand their ethical obligations working for, especially for a public company, extend beyond their employment relationship. And I'm not here waving the flag for whistleblowing, but I have protected whistleblowers and I have encouraged whistleblowers. And I feel very strongly, very strongly, about the need for whistleblowers because they are that secret channel to transparency. They are the ultimate trump card for transparency. And this is what it's about. And I really want people to understand this. This is not about a breach and a company getting punished for the breach. This is not a CISO getting held out to, as a scapegoat because he allowed the breach to occur. Look, you can do everything right and the breach will still happen. Some idiot clicks on a link and you get breached. We're not talking about that. We're talking about knowing exactly where you stand in your posture. And the only way to know that is to continuously validate your controls. That's it. You need to put your compliance in real time. I hate to say it, and I know I work for a vendor that sells this kind of an idea and sells this kind of platform. But frankly, the reason we created this platform is because we're so passionate about this notion of continuous compliance, not doing it every 3 months, 3 years, a year, whatever, not waiting for the audit. The breach is the ultimate audit. And when that happens, what is the day 2 conversation you're going to be having when the regulators come to town and say, why is there a delta between what you claimed about your security posture and then all these things that we just saw? Look, you can do right and still get breached, and that's okay. Everybody gets a pass for that. But if you were being negligent, willfully negligent, and then lying about it, that's just fraud. And that's illegal.
This case is a good example. It's a good teaching opportunity for all the CISOs out there. Like we've been saying, they have skin in the game now, and so if you're not being heard, then you need to remind them you have skin in the game. If you're still not being heard, then you might need to go and offer your talents somewhere else, but you're still going to get the same kind of treatment because people want you to fix things. So a lot of CISOs are brought in after something bad happens. So they're brought in to clean up something bad. So they're walking into a hot mess anyway. And it's, can you turn this hot mess around? Oh, he was ineffective at this job or whatever, and we got rid of him because this happened. They're not disposable people. It's a highly technical skill set. And there's somebody that you need on your team. You need to be able to trust them. Now, one more thing about whistleblowers. Please get advice from these attorneys that specialize in this work. If you have any questions about this, this is not something that you just go start blasting out on Twitter or whatever, just to gaslight your company. That's not the way to go about this. So seek help before you do anything. If you get pushed all the way to the limit till you get to that point, But another thing that I saw was fascinating, the Wirecard fraud scandal. You remember that one? It's one of the, it was one of the largest in history. The whistleblower there was one of their lawyers, and he has since gone on to build a tool for companies to use so that it routes your whistleblowers to the people that need to hear what's going on so that it can help companies better navigate this. Because I've always said whistleblowers exist because of shitty middle management. So if you don't listen to your people, then your people are going to find someone else to talk to and you're not going to like it. So I thought that was an interesting innovation that he came up with. I have not seen the tool or tested the tool, but I thought that was an interesting way to go about it from somebody who's been in that situation. So maybe businesses are starting to pay more attention. Compliance isn't really a cost center. It also is part of your marketing. And it's an important, all of the data in your life cycle has different kinds of considerations to be made, not just privacy and security, but effectiveness. What do you have data quality issues? Have you resolved those? All kinds of things are throughout the pipeline. So a full audit is something good. If you haven't undergone a full audit of your pipeline to map it and find out where your gaps are in your assessment of your pipeline, that I would recommend you talk to people who know how to do that. Code scanners, those sorts of things. Have you tagged your data correctly? Those kinds of things. Because if you just knee-jerk reaction to every regulation that's come out in the last 18 months, like you're covered in Band-Aids right now. So you may need to do some structural changes to improve the overall performance of your system, including increasing your security where you have gaps.
Absolutely. And you said Band-Aids, and I'm also fond of saying Band-Aid mummies. I mean, like a lot of these companies are walking around like Band-Aid mummies, just patches. And like very few have the opportunity or the luxury of kind of doing a green field or white field, just starting from scratch. Let's break everything down. You're running a business. You've got billions of dollars going through. You've got shareholders, you've got consumers, you've got all kinds of stakeholders. It's just impossible, right? So you kind of have to take a staged approach. You have to pick your battles. You have to prioritize the different risks. But that's where the strategy comes in, right? You have to have a good strategy. And look, my title is VP of Compliance Strategy. People go, what's compliance strategy? What's there to strategize? These are the kinds of things that you strategize about. These are the kinds of things you think about is how can I compliance investments, which, by the way, most security programs spend most money on compliance, not security, even though they're ostensibly security programs. Guess what? You're already spending the money on it. You're required to spend the money on it. Do it smart. Use compliance as a consistent model of managing risk because you've got the frameworks, you've got the standards, you've got the mandates, you've got all the control frameworks, right? All of it is right there. It gives you complete detailed guidance. And it's arcane and it's very imperceptible. It's precise, but it's hard to perceive. It's hard to manage. You have to have specialists who understand it from kind of a legal, quasi-legal perspective. You have to have compliance context. You have to have technical context. It's a hard skill to blend together, and it's hard to keep these people around, right? And if they're really good, they become auditors and they leave anyway. And now they're auditing, right? They're going 2 weeks here, 2 weeks there, right? So how do we take all the power of compliance, and we turn it into a real tool of security and risk management, right? And as you said, right, the external communication about the risk posture, compliance is the vehicle, and audit has been sort of the medium through which we communicate these things. But we know it's imperfect.
This is your compliance documents, that's marketing materials. Your privacy notice, that's marketing materials. You're marketing to regulators. I know what the rules are, and here's what I'm doing about it. Also, the general public, you can trust me for these reasons. I mean, I think that's definitely important too. I'm glad we had this chat. And just to let CISOs know, you need to be nervous. I know it's right. You're not used to having this kind of friction come at you.
No,
telling you for a while. So I am good with how uncomfortable people are right now. I would encourage more people to spread the word to their friends so that they're also a little bit more uncomfortable too. So that we can start to bring about change. These cases come about so that businesses know what the rules are, and we have a deterrent effect so that other businesses will know what they need to do. That is where we are right now. So it's what do we need to do so we don't get in this situation. So as far as I'm concerned, all of the auditors and the data scientists and, the technicians and people that I know that do this kind of work, I want them to be as busy as possible right now, because this is when people need to start making changes, not when something bad happens. You need to do something now. So like you said, there's strategy that's involved in here, depending on the scale of your infrastructure and your supply chain. What are you doing? So at this point, ask questions. And if you have questions, you need to let people know where to bring those questions, not necessarily off the cuff remarks in Slack. But if you do pick up on something like that from an employee, I would say take that into a regular internal work system so that you can address the issue and have it documented, because that's the proper way to deal with these things. So, it's quick to send somebody a thumbs up, like, I hate compliance. Yeah, thumbs up. Like, that's not look. Yeah, SBF. He's facing 110 years for his FTX tricks, and the jury heard. Yeah, the jury heard him, screw PR and screw regulators and all that. And they're like, oh, yeah, it took him 4 hours. He's eligible for 110 years of prison time. We'll see what he gets.
Yep.
Yeah, so don't think people aren't looking at your Slack and things like that. So it's ephemeral messaging. Screenshots are forever. I'll just say that. But right. So on that note, I'm going to have to jump because our time has come to an end, Doctor.
Thank you.
I'm so sorry.
It was a pleasure. Thank you so much for your perspective. Always love having you on. Hopefully we'll do it again soon. Hopefully we don't have to do it soon, but I'd love to have you on soon again.
I bet we will.
In a couple of weeks. Again, thank you. Have a great one. Take care.
Thank you.